come out of its non-public session for the 23 October regular select board meeting. And we'll now move to a public hearing. All in favor?
Aye.
Aye. Okay, so a public hearing will be on the 4114-A on the land donation of the what we just simply call the Britton property, but which we've specified exactly what it is in the handouts that we've provided over the last almost a month now. I think we had our first meeting on the 26th of September, our first public hearing. And then we had a second public hearing as required on the 10th of October. So the purpose of this public hearing is to take any remaining comments that anybody has, residents, property owners, or interested parties, and close the public hearing. And then the select board, which in this case is Wendy and I, will discuss, deliberate, and vote on the proposed donation. So that's the plan. Would anybody like to address the board? Any further comments on the land proposal, land donation proposal?
Yes, hi, Terry Stutzman.
Yeah. Terry, would you mind? We've just been asking everybody could you move the microphone up, because we've had complaints that people can't see or hear. Yeah, if you move it over to your right, just so, yeah. There we go. That's good. Thank you. Thank you very much.
Questions. I wasn't able to attend the last public session. For the record, Terry Stutzman, 60 Osceola Road, at the September 26th, I believe it was. Planning board meeting, we had discussed the environmental consultant review and the legal review. And at that meeting, I think, Mr. Dakota, I appreciate you sending me this packet, but I thought we were going to see on the town website that I couldn't find the actual written review and legal review from the attorney.
What is included in the packet under it's termed key environmental considerations. That is the public summary of the legal document. The legal document was for the board's review.
Okay, and that's not a public document.
It's not a public document. It's attorney-client privilege to the board.
Okay. All right, and just a recommendation from somebody who has a lot of background in communicating. Because it's not a public document, I don't think there's any ill will by the select board at all. It feels like we're not getting all the information. I do see that there's a summary, but it just, as a taxpayer, I'd feel more comfortable supporting the donation if we had some maybe liability shifted to our attorney on what the potential cost is going to be. I don't know. I mean, I know what from this summary, what you would like to do as a board, but I don't really feel like we have solid information on what our potential liability is for the landfill should a cleanup ever need to happen, and what it's going to cost, and what DES, Department of Environmental Services for the state, might require of us, and have we taken any steps to figure out what the federal government and the EPA might require of us for cleanup, and where are the numbers for what it would cost if we're the deed holder or Mr. Britton remains the deed holder. So that was my primary concern. I just, for the record, also want everyone to understand, I want to keep the property as it is right now as well, because I use it all the time. It is a beautiful, special piece of open land right now, but I just don't feel like we have all the information to know what this is going to cost us long term. And the other piece that I came away with after reviewing the YouTube video is your concern, and understandable concern, that the property, if it gets developed, is out of our control as a town. And there are a variety of things you could do in a recreational zone, but where I take issue is when I had that property under agreement with my husband, we researched what was available and appropriate and within zoning. There's not much. It's a flood zone. I've heard crazy rumors floating around like goat farm. Well, since Waterville Company was trying to sell the property for a number of years, You don't see goat farmers running up the road to establish a business in Waterville Valley. And it just feels like this is a little bit rushed, because I don't think Mr. Britton would have moved forward with trying to sell it to the town if there were other developers. So that's my question. I'll let you address it.
Okay, let me just see if anyone else has any comments, and then Wendy and I will address all the questions. Anybody else would like to talk on the matter in front of the board? Yes.
Ken Wenger, Birchburg Lane. Mark, the last meeting you talked about being a PRP.
Mhm.
Could you just restate what you had said at that meeting?
Right, our potentially responsible party under the regulations or under the legal requirements for the cleanup. A PRP is an entity that is responsible for paying for cleanup if it has to happen. So the conclusion that our town attorney had was whoever owned the property, in all likelihood, the town would be a potentially responsible party and have to participate in the cleanup.
We would have quote
Yeah.
unquote strict liability, I believe
Right.
was the term he used,
Yeah.
Right, I
or the
think that-
firm used.
Right,
Yeah, no, I spent 10 years at EPA
Mhm.
as a Superfund
yeah,
project manager,
Mhm.
cleaning
Right.
these problems up. So being what you're proposing is definitely the thing to do.
right,
Okay, because if someone else buys it, and I think you said this at the
Yes.
meeting as well, someone else buys it and wants to do something,
Right.
we're still gonna have to.
we still
covered.
would,
So it is best for us to control our destiny.
Right.
Own the property and then prevent anything else from happening to it by somebody else.
And just to clarify, you'd mentioned town attorney, but we did go to a specialist, another company. We didn't work with our regular town attorney, went to Rathgang and Pignatelli
Yeah.
because they have more of a specialization with land use issues.
Any other comments or observations? Okay, just to address Terry's questions, the summary that says key environmental considerations, we asked our legal firm to provide that to us. That is not the board's or town staff's summary. That is their summary of their legal opinion that they felt comfortable being released as a public document. With regard to the two other issues you raised, my opinions, Wendy may have a different opinion. Perhaps we just have a disagreement on what could happen in recreational zone land. Being part of a flood plain doesn't necessarily make it impossible to develop that land for recreational purposes. One thing that comes to my mind, for example, would be pickleball courts or tennis courts or any other sort of structure or facility that where of issue of flood isn't as great a concern as, say, a structure may be. With regard to farming, I think it's out of our hands. I mean, that's a state regulation, I think, in every zone. So there's nothing we can do. If someone wanted to, I forget what it is, 5 acres or something. We are required by state law in any zone to allow that to happen. So maybe we just, at least with me, I have a different opinion about how valuable that land may be for development. As to you raised the question of cost, there's no way really for us to get at it until we find out what remediation needs to be done. And from what both our environmental consultant and our legal firm told us, that it would be best for us to work with the state to try to find out and to work with them and minimize the cost of and the methods, the testing that we would necessarily have to do. And we've begun preliminary discussions with the state on that matter. But at this point, not knowing exactly what's going to be required of us, whether we were the owner or not, we can't really put a cost estimate to it. What we have been told is that in situations like this is what our environmental consultant and our legal firm told us. In situations like this is not new. Towns in New Hampshire had gone through this many, many times. They just seem to have forgotten Waterville Valley, but this is a pre-1981 unlined landfill town dump. Every town had one. A lot of them were closed over the past couple decades, and the requirement was to put clean fill of up to 2 feet. What is it? 2 feet? I forget.
Several feet. I don't.
Yeah.
Well, I can't remember on top of the areas that where the dumping occurred. And so, if we can get that with the state, we would, and that would not be cheap. I'm not trying to minimize it. That's certainly on 13 and a half, depending on how much of the area and how much they want us to do. It may be, the state may require us to go to a level 2 test. I think that had come up. We're talking to them about what they would require from us once we acquire the property, but these requirements would be the minimum if we didn't own the property and then someone wanted to come in and actually build structures on there, and we'd have to remove material, for example. So I guess that's where I was coming from and looking at this and interpreting the legal environmental comments that we received. Wendy?
Yeah, I think just to elaborate on that a little bit, the other issue we have is working potentially with the EPA as well, because of the Shoreline Protection Act. So we have the EPA and the state, and just making sure that everyone's on the same page to keep it as we all want it. I think there's a general consensus that we're hearing that everyone appreciates having the open land, the ability to use it, having it free for everybody. So it's just a matter of another unknown influence is, how the EPA will react as well, if they react.
Right. And another part of that too is seeing to what extent we want to, part of this is wetlands, but to what extent do we want to put some of this land into conservation status to prevent future development? That's something we'd have to discuss with the Conservation Commission once we were to acquire the property. But at this, as I understood the legal opinion, there are 3 potentially responsible parties. They've been the original owner, the Waterville Company, which no longer exists, the current owner, Mr. Britton, and the town of Waterville Valley, which under some agreement, of a copy of which we've never been able to find, operated an unlined landfill on this private property for a number of years. And that seems to be the main thing that both our environmental consultant and our legal firm indicated as being making our defenses against being responsible for cleaning it up, the primary party responsible, if not the sole party responsible for cleaning up, very difficult to achieve, very difficult to defend, since we operated the landfill. Anyway, yes, please, we're still in the public hearing. Go ahead, Charles.
Yes, my name is Charles Hastings. I live on Noon Peak Road, and I'm speaking as a resident, also as a member of the Conservation Commission. I actually enjoyed, even though I've been following this issue for a long time, I enjoyed reading through the details in the little PowerPoint that was sent out, and I learned something more still, so that's really good. And one is that it discusses the circumstances under which the select board can buy or sell property. And it specifies that the select board cannot sell property if it is controlled by such entities as a conservation commission. And to my mind, that means that if, and this has been part of the discussion all along, at some point, part or all, we don't know for sure what, of this property is in some way put under the control of the Conservation Commission, perhaps to become greenbelt or whatever other category. If the Commission has some new authority over this, that is an added layer of protection against possibly having it ever developed, or against the environmental authorities at some level asking us to proceed to a level 2 process of doing very extensive testing and burial of much of the land. My impression is that as long as there is no prospect of this getting substantially developed or disturbed, there is going to be relatively little need or pressure to do major restoration of this in any way. And so I took some comfort from that knowledge that it adds another layer of protection to do what Terry and all of us want, is, maybe not all, most of us, to leave this land as undisturbed as possible, as some of the last remaining open green land in the valley. And so I think there are even better built-in protections than I thought. And I think I look forward, as a member of the Conservation Commission, once this is resolved, to working out how we're going to deal with the future fate of this piece of land. Thank you.
It's a very good point. Thank you. Thank you, Charles. And in fact, I mean, I think that's one of the points we intend to raise with DES about the conservation of this land and how that would impact their view of what we would necessarily need to do if we did this to the land. So I think it is could be an important selling point with DES. Again, we've had very preliminary discussions, they're more of the what if, this is what's going on. We wanted to be upfront with DES and just say, look, this is, in our laps, we may or may not acquire it, but in any stead, what would have to be done? And the initial discussion seemed to be this soil clean fill cap as the most likely procedure, although there is some question about testing. We may have to do further testing to just do a clean soil cap. Anything on it?
Yep.
Any other comments, questions? Okay, why don't I just go ahead and close the public hearing, and then Wendy and I will now discuss it in front of everybody. So, I mean, the process here is we've been at this, it seems like, for years.
Feels that way.
Actually, we have been. I mean, this land was first offered to the town when Waterville Valley decided to liquidate and sell all its properties, this and several other parcels. I believe we bought 2 parcels, if I'm not mistaken, from the Waterville company. I was on a select board at the time, but I remember we turned down pursuing this because we were concerned that as the owner, we would be we'd be liable for the cleanup. At the time, we saw some indication that the town may have officially operated a dump there, but it was very hazy. And so we just decided not to pursue it. Ultimately, the Waterville company sold it to Mr. Britton. And then he offered it to the town first to purchase it at the assessed value, which was rejected at town meeting. Although although the majority of people voted for it, I think I want to say 70 to 50, something like that. It was 2 votes shy of the 60% needed for a bond. We would have bonded the sale. So with that result, we left it alone. We had no further discussions with Mr. Britton until he came to us, I think it was in the spring of this year, and said he would like to donate the land. At that point, the board decided that it would be worthwhile, given the concerns expressed at town meeting and given especially about liability, it would be in the town's interest to spend some money just to get an environmental a phase 1 environmental assessment of the property, which we did, which was based more or less a document check. And that document check turned up a number of documents which clearly show that the town operated an unlined landfill at that position. And also, we did soil testing to see exactly what was there and preliminary, I think it really preliminary soil testing, right? To see what was there and where it was located. And it's in the environmental report that's available. And a lot of it's scattered about, but most of it is in that one corner, that cleared area when you first walk into West Branch, off of West Branch Road on the left, that cleared area. That was the main area that was used to dump what seems primarily to be municipal solid waste, i.e. household trash. It's not the only thing in there, but that seems to be what the vast majority of the material was. So based on that, we decided, well, we better get a legal opinion on this. So we went to this firm known for work in this area. And you see the summary of what they wrote, that we would have strict liability and our defenses would not be great. Matter of fact, they said it would be rather poor in being responsible for the cleanup, especially since one of the parties no longer exists, and it was the town which operated the landfill on this property. We are at this moment, liable to be sued for cleanup. That could be done at any time. In any event, that's, I guess, the quick thumbnail version of where we've been and how we've got where we've gotten.
Yeah.
Wendy, would you like to add anything? I'm doing
I
a
think
lot of
you've-
talking
you've-
here. I
you've
think you need
really-
to do some talk. Oh, we have one more. We have some correspondence from a resident in support of us. So I'd like to enter that into the record
For accepting the donation.
for accepting the donation.
Yes, and I think it's important to note the generosity of donating this land to the town with the idea of wanting to enable people now and in the future to use it as it is currently.
Yeah. And I think that's the point is, I think too, that the select board has tried to be very flexible. We today want to leave it as is, and we can't imagine that future select boards or town meetings would not want to use it in some way that we don't agree with now, or we aren't thinking about now. But owning the property, it would mean that a future select board, future town meeting will be able to decide what to do with that property beyond what we think ought to be done. Now, again, much of that downstream is going to be, I think, dependent upon what DES requires us to do with regard to remediating the damage to the property, and whether or not we pursue, or how extensively, I should say, we pursue putting this land in conservation status. So I think we want to keep it the way it is. But please recognize that future select boards, future town meetings, its town property, can decide what they want to do with the land based on whatever the parameters are at the time. I think if we do accept the land, the process going forward would be to open negotiations with the current landowner in a purchase and sales agreement. That's how this generally would work. I think we would like to get that done by the end of the year. And then at that point, decide whether we want to, well, see what DES says, and then go from there as to what we want to do with regard to conservation status of the land. I think that would be the next step after DES. So that's sort of the future as I see it.
Yep.
Shall I make a motion or she'll make a motion?
I can make the motion.
Please.
Sure. So I'd move that we would accept the donation of the property at 49 West Branch Road, map 103, lot 23 on town tax maps from David Britton.
All right, I will second that motion. All in favor?
Aye.
Aye. The motion passes. Thank you, everybody, for attending. And I think that's the last order of business we had for this regular meeting. So I would like to adjourn the meeting. Do I have a motion to adjourn?
So moved.
Meeting is adjourned. I didn't know you worked at the EPA
Yeah.
for 10 years. You're such a normal guy. I mean, how did that happen? You must have been like the odd man